Hi, welcome everyone. My name is Cassandra Spangler. I'm a music attorney based out of New York City. This is my lecture for the 2013 IndieConnect Virtual Music Conference. The title of my lecture today is Intellectual Property Primer, the difference between a patent, a trademark, and a copyright. Just a little disclaimer before we get started. This lecture is not intended in any way to be legal advice. If you do have questions or issues related to intellectual property, you always want to consult with an attorney so that they can help assist you with the particulars of your case. This is just simply intended to give you an overview of the different concepts involved so that when you do go consult with an attorney, you'll have a better understanding of what it is that you're looking to do. Okay, starting with patents, I'm going to move pretty quickly through this section because I think of the three types of intellectual property that we're covering today, patents is probably the one that you will encounter the least in the music industry. Obviously, if you're a tech company or a .com, you're going to have a lot of interaction with patents. But as an artist or a record label or an artist manager, I think you're going to deal a lot more with trademarks and copyright. Just one other small disclaimer when it comes to patents in particular. In order to practice patent law, you do have to be a licensed patent attorney, which requires passing an additional exam beyond just being a member of the bar. There are also people called patent agents who are not attorneys but who are also licensed to deal with certain patent issues. I'm neither a patent attorney nor a patent agent, so again, if you do have questions about patents, you want to consult with a licensed patent attorney or patent agent. Okay, what is a patent? Broadly speaking, a patent protects an idea or an invention. Once the patent is issued, it grants you the right to prohibit others from using your idea or your invention. In general, in the U.S., once the patent is issued, that protection will last for about 20 years. Patent applications are filed with the U.S. Patent and Trademark Office. The electronic filing fee ranges from about $100 to about $400, depending on the size of your business and the type of application that you're filing. Paper applications are much more expensive, which is also true with trademarks and copyrights. So if you can file the application online electronically, it will save you some money to do so. Inventors can file their own patent applications, however, it's strongly discouraged. I think it's safe to say that of the three types of applications, patents are by far the most involved and the most difficult to complete. Many patent attorneys also have advanced degrees in engineering, just to give you an idea about how complex an area of the law this is. So it's really not something you want to try and do yourself. It's really to your benefit to hire a patent attorney or a patent agent to guide you through that process. Okay, moving on to trademarks. Just a little introductory note. Trademarks are used when you're referring to products, and service marks are used when you're referring to services. However, just to make things easier, I'm just going to say trademarks throughout this lecture, but understand that for the most part, whatever I'm saying about trademarks applies equally to service marks as well. What is a trademark? A trademark is a word, a logo, or a package design, or some combination of the three, that is used by a manufacturer or a merchant to identify its products or services and to help distinguish them from the products or services of others. A trademark is what you want for your band name, your company name, your logo, which is important to understand because I often get people contacting me asking to copyright their band name. Unfortunately, you can't copyright a band name. However, if you meet the requirements, you may be able to get some trademark protection in it. Trademark protection is really intended to protect the consumer. By granting companies trademark protection, it allows the consumer a certain level of confidence that when you walk into a store and you pick up a product with a certain brand name on it, you know where it's coming from. So for example, if you walk into Guitar Center and you pick up a guitar that says Fender on it, you know that it's manufactured by Fender, that it's going to have a certain history behind it, it's going to have a certain level of quality, it's going to have a certain sound, etc. It also provides incentive to companies to be consistent with their quality. Trademark protection prohibits others from using a mark which is confusingly similar to your mark, which means that a consumer could reasonably think that a product or service bearing the other mark came from you. So going back to the Fender example, you most likely would not be able to sell guitars called Trender guitars because a consumer could reasonably walk into that guitar store, see a Fender guitar, and think that it came from Fender when in fact it did not. In order to qualify for trademark protection, your mark has to be distinctive. There's sort of a sliding scale of distinctiveness which is used. On one hand, we have words which are completely made up and don't have any meaning other than being the name of your brand, and those are the most distinctive and they're going to get the most protection. On the other level of the spectrum, we have marks which simply describe the product, and those are the least distinctive and get the least protection. So again, with the guitar example, if you wanted to call your company the Electric Guitar Company, that's going to be the least distinctive type of mark because it simply describes the product that you're selling. Whereas if you make up a word and use that as the name of your company, it's going to be more distinctive and probably get more protection. There are also certain types of words that cannot be trademarked. For example, last names and geographic places. So that's just something to consider when you're starting a new company or you're starting a new band and you're trying to come up with a name. The more distinctive you can make it, it might help you get more trademark protection in it down the road. Trademark protection is established by use in commerce. So in that way it's different from patents and copyrights because in order to get protection for your trademark, you have to use it first. You can file what is called an intent to use application, which can help to reserve the mark for you so that when you do begin using it, it makes it easier for you to get the protection in it. However, in order to actually get the protection, you have to use it first. So for federal protection, you have to not only use it in commerce, but you have to use it in interstate commerce, which means in more than one state. This is a requirement that historically used to trip some people up, but nowadays with the prevalence of the internet, most companies have websites where their products and their services are available. It doesn't even have to be your own website, it can be a third-party website. So, for example, if your music is available on iTunes, you most likely will qualify for the interstate commerce requirement because people in multiple states can purchase your music. If you are primarily a touring band and you don't really sell recorded music, you may be able to meet the requirement by, for example, playing shows in more than one state. Something important to note is that in order to use that little circle R symbol, you do have to have a federally registered trademark. So if you have not federally registered your trademark, you can't use that symbol. You can, however, use the little TM symbol that you might have seen. You can use that without a federal registration. In addition to federal registration, some states also offer their own trademark protection. So if for some reason you can't meet the requirements for federal registration, you may still be able to get some protection in your own state. However, it's always preferable to get the federal registration if you can, because the state protection will be limited to your state. You can also establish a certain level of protection without registering the mark simply by using it. However, in that case, the protection, again, is going to be limited to the geographic area where you're using the mark. So this can create a lot of issues. For example, if you're a band who is known primarily in the Northeast, you may be able to establish a certain level of protection for your band name because you're using it, but that protection is going to be limited to the Northeast unless you register the name. And without registering it, there's nothing to stop a band, for example, in California, from using the same name and establishing their own protection there. And that becomes a problem if either or both bands want to expand and go nationwide. The band in the Northeast may be prohibited from using their name in California and vice versa. So if you can get that federal registration, again, it's really preferable that you do so. The federal applications are filed with the U.S. Patent and Trademark Office. The electronic filing fee is about $300. Again, you can file the application yourself, but it's not recommended that you do so. You should consult with a trademark attorney to help you through the process. Also, unlike patents and copyrights, where the protection expires after a certain number of years regardless of whether you're using them, trademark protection can continue for as long as you continue to use the mark. There are two ways that you can lose that protection. The first is if you let your mark become what is called generic, which means that the word becomes so common that people begin to use it to refer to the type of product rather than the source of the product. A famous example of this is the word zipper. Zipper actually started out as a protected trademark. It referred to zippers that came from a particular manufacturer. However, people begin to use the word zipper as we do now to refer to zippers as a noun coming from any manufacturer. And as a result, the trademark became generic and they lost their protection in it. The second way you can lose your trademark protection is if you what is called abandon the mark, which basically just means that you stop using it. So I think that about covers the basics of trademarks. Again, this is what you want for your band name, your company name, your logo. Okay, moving on to the third and final type of intellectual property that we're going to cover today, copyrights, my own personal favorite. Copyrights protect the expression of an original idea. It's important to note that it's the expression which is protected and not the idea itself. Again, ideas fall more into the category of patents. That expression can be a musical composition, a sound recording, a literary work, a dramatic work, a film, visual art, photography, etc. In order to be copyrightable, the work has to be, first of all, original enough. So if you simply draw a stick figure, it may not qualify for the originality requirement. Second requirement is that it has to be what is called fixed in a tangible medium. So if you sit down in a room and you write a song, but you don't record it and you don't write down the lyrics, there's no copyright there. However, the moment you record that song or write down the lyrics, they become copyrighted, provided that they meet the originality requirement. In general, the copyright belongs to the author of the work, exceptions being if it's a work for hire. I'm not going to go too far into detail there, but just understand that in general, unless there's something that's been signed to the contrary, the copyright is going to belong to the author. On that note, any transfer of a copyright has to be in writing. So if somebody verbally transfers their copyright to you, that's not going to be valid. It does have to be in writing, signed by the person that's transferring ownership. Copyright grants what is called a bundle of rights, which includes the right to reproduce the work, the right to prepare derivative works of it, the right to distribute the work, the right to publicly perform the work, and the right to publicly display the work. So this is where you get into licensing, because if you own the copyright, you own all of those rights, and you can license them out either as a whole or individually. So for example, you might give someone a license to distribute your work, but not to publicly perform it. Copyrights can be registered with the Copyright Office. It's really important to understand, however, that the copyright exists even if you don't register it. So the moment you sit down and record that original song, you own the copyright in it, even if you don't register that copyright. However, that being said, there are a lot of benefits to registering the copyright. The first being that if you get into a situation where someone is infringing your copyright and you need to take it to court, you more than likely want to take it to federal court because it's federal law which is involved. And in order to file a copyright lawsuit in federal court, you have to first register the copyright. The second benefit of registration is that it helps to establish what is called priority, which means that it helps to establish the date that you created the work. So again, if you write that song on February 1st, 2013, and you register the copyright the next day, and then 2 years later, somebody comes along and writes a song that you feel is infringing on your copyright, you have on file with the government agency, the Copyright Office, proof that you wrote the song at least as early as February 2nd, 2013. The third benefit of registering your copyright is that then the information becomes available on the Copyright Office website database, so that if somebody likes your song and wants to license it, they can search on the Copyright Office database, find out who owns the copyright, who administers it, and then get in touch with you about licensing it. It's very frustrating when people come to me and, for example, they want to get a license to sample something in their music, and I can't track down who owns or who administers the copyright in the original. because in that situation it's lose-lose for everyone, because the client can't sample the work because we can't find, who to reach out to get a license, and the owner of the original is losing out on potential licensing income. So again, once you register it on the Copyright Office website, it makes it easy for people to get in touch with you if they do want to license it. Unlike the circle R symbol, you can use the circle with the C in it without registering your copyright. So copyright, this is what you want for your music. And an important concept there to understand is that in every recorded song, there are at least two separate sets of copyrights. On one hand, there's the copyright in the recording, the master. Totally separate from that, there's the copyright in the underlying composition. This is sometimes a hard concept for people to wrap their head around, especially artists who write all of their own music. But it's easier to understand when you think about an example where someone is recording a cover song. In that case, the artist who's recording the cover song is going to own the copyright in the sound recording. However, they don't own the copyright in the underlying composition because they didn't write the song. So that copyright remains with the original writer. Copyrights in the sound recordings are generally owned by record labels. Pretty much every record contract that you will see requires you to sign over your rights in the master, which means that you're signing over your copyrights in the sound recording to the record label. Copyrights in the composition are generally owned, at least in part, and administered by publishing companies. So if you want to sample something, for example, and you want to get a license, you need a license not only from the owner of the sound recording that you're sampling, which will most likely be a record label, but you also need a license from the owner of the composition, which most likely will be a publishing company. On that note, it's also important to understand that registering your works with a performing rights organization such as ASCAP or BMI, well, it's very important to do that because this way you can make sure you're getting all of your public performance income. It's not the same thing as registering the copyright. The copyright, in order to register that, it has to be done through the Copyright Office. With some exceptions, copyright protection in the U.S. for works that were created after 1978 will last for the life of the author plus 70 years. Again, there are exceptions when you're dealing with an anonymous work, a work with a corporate author, etc. But that just gives you a general idea. After the copyright protection expires, the work goes into what is called the public domain, which means that it's free for anyone to use and it's no longer protected by copyright. This is why when you walk into a bookstore and you see 50 different versions of a Shakespeare play, it's because all of those works have gone into the public domain and anyone is free to publish them. They're no longer copyrighted. Just one final note on copyright infringement. I'm not going to go too much into detail there because it really is a topic for another lecture. But understand that whenever you're using a copyrighted work that doesn't belong to you and you're doing any of those things that we talked about being in that bundle of rights, you do need a license. And without a license, you are committing copyright infringement. So it really doesn't matter if what you're doing is commercial or non-commercial use. While that is a factor that the court would consider, just because something is non-commercial use does not automatically mean that it's not copyright infringement. And I think there's a lot of misconception among artists there. So it's just important to be aware of that so that you don't run into trouble down the road. So again, anytime you want to use something that's copyrighted that doesn't belong to you, you want to consult with an intellectual property attorney, and they can help you get the proper licenses. So that about covers copyright. And we've come to the end of my lecture. Just to summarize what we've talked about today, patents protect, in general, ideas and inventions. Trademarks in general protect brand names, logos, things like that. And copyright protects artistic expression. So that's, what you would want for your music. I believe all my contact info is available on the IndieConnect website, so if you have any questions or any issues related to anything that I've discussed today, please feel free to get in touch with me at any time. I also want to give a little thank you to Diana Barnes, who is the president of the New York City chapter of IndieConnect, as well as the president of Suede Artist Management. I wanted to thank her for inviting me to participate in this conference and give this lecture today. All right.